table.
Good morning, Mr. Johnson.
My lords, my lady, yesterday afternoon His Lordship the Master of the Rolls invited me to provide some authority on the proposition that the CPR is a new procedure.
Which you've done very helpfully, thank you.
Which I have endeavoured to do. I have hard copies of the materials if any of you would like them, but I'm grateful for that indication. On Nomura and Granada Group, the key point is, as you will have seen in paragraph 25 of the judgment, that the RSC and the learning in relation to it may be taken into account where the new rule under the CPR follows the same form and appears to have the same underlying intention. Now, we've had a lot of debate about Rule 7.3 and Order 15, Rule 4, and it is not altogether clear that it has the same, that the new rule has the same form as the predecessor. But there is more to be said in relation to the underlying intention. The key point, however, arising from this in my submission is that convenient disposal under Rule 7.3 is not and cannot be narrower than what Order 15, Rule 4 permitted. And I say that my client's case falls within Order 15, Rule 4 in any event, and say that the underlying intention drawn from Order 15, Rule 4 advantages the respondents, not the appellant. And I think I need to say no more about that unless your lordships and my lady have any questions in relation.
Well, could we look at 15.5 just briefly?
Order 15, Rule 5.
Yes, it's just because my lady has just pointed out to me something I had not realised, and it's in the bundle, I think,
yes,
at page 370 something. So we looked at 15.4, but 15.5 is at page 388. If claims in respect of two or more causes of action are included by a plaintiff, or if two or more plaintiffs are parties to the same action, and it appears to the court that the joinder of causes of action may embarrass or delay the trial, or is otherwise inconvenient, the court may order separate trials, or make such order as may be expedient. So the word convenient does appear,
yes,
albeit in a slightly different context,
yes,
in the RSC.
Yes.
Yeah.
This rule has a similarly long pedigree as Rule 4.
Right.
And it's referred to in Hannay and Smurthwaite because one of the questions in Hannay and Smurthwaite was, did the rule permitting joinder of parties enable the court to entertain the writ naming the multiple plaintiffs? The Court of Appeal had or made reference to this provision, or the predecessor of this provision, Rule 5, which dealt with joinder of causes of action, and said that in the light of the provision on joinder of causes of action, the writ was properly constituted. The House of Lords disagreed with that analysis and said you could only look at the rule concerning joinder of parties, and that was limited by reference to the relief that was being sought. You had to have an interest in the relief, singular. And so there is some historical context to this, but and indeed in Hannay and Smurthwaite, even the Court of Appeal said that entertaining the writ with the multiple plaintiffs was, as far as the court was concerned, fine, and it was then up to the defendant to make an application to separate the causes of action, if so minded, under the predecessor of this rule.
I mean, all I think my lady was suggesting to me was that the word convenient appears not to have come out of nowhere.
No, and I don't object to that observation in any way.
No.
And that is not unhelpful when one looks at the Nomura guidance.
Which paragraph of Nomura was it?
25, my lord. And it is it's just under the heading "The Law," page 13 of the soft copy.
Yes.
And
the heading "The Law," yes. 25.
Yes. And what Mr. Justice Cook was saying is that there are cases that go both ways, but the principle he extracts is that the courts have drawn upon decisions relating to the RSC where the new rule under the CPR follows the same form and appears to have the same underlying intention.
This doesn't follow the same form, does
No.
it? But even so, it's the important part is it goes both ways. I mean, there's no indication in the Wolf report, which may or may not be admissible as a tool of statutory construction, but there's no indication in the Wolf report, which is really something we always used to look at in the early 2000s, to say that there was an intention to do away with the old provisions.
No, absolutely. And we say that the old provisions are consistent with the issue of the claim form in this case.
And neither party here has argued that the Wolf report is inadmissible.
No, and in fact both parties have referred to it in the skeleton arguments.
Well, just on this, would your lordships just be kind enough to read 25 and 26 to avoid me coming back to it in reply?
Yes,
The whole of 25
certainly,
and 26.
certainly. Let's just do that. Yeah.
The rupture of procedural law is in fact the decision of Master Davison at first instance in the Abbott litigation. That's what's gone wrong in this area of the law, not in fact the operation of Rules 7.3 and 19.1. There is no suggestion prior to the Master's decision of any difficulty with multiple claimant claim forms. And if there were, it would be reflected in the reported cases and would probably have reached this court before now. And the divisional court has done its best to straighten out the construction of Rule 7.3 and 19.1. And you've heard me say it, forgive me for repeating the position, we say the same situation would have obtained under the old rules in any event. So that is the rupture. It's not the change to the rules, it's actually that aberrant decision. The only other point on Nomura is that I provided your lordships and your ladyship with an extract from volume 2 of the CPR, which deals with the significance of the rules as a new procedural code and reliance on pre-CPR authorities in quite a lot of detail. The last paragraph of that particular extract, just above 1253 on the last page, refers to Nomura and says that it is a correct summary of the principles.
I think,
So-
curiously enough, that Rule 1.1 no longer describes itself as a new procedural code.
Well, perhaps in the light of these sorts of debates, my lord. But in any case, that's the last thing I wanted to say about Nomura. Mr. Stewart KC has made clear that there is another authority that he has brought along, which is called Baguzzi, and that's just dealing with the proposition that whilst Lord Wolfe had said on an earlier occasion that one must treat the CPR as a new procedural code and not look at the old authorities, in Baguzzi the Court of Appeal said that one should not discard all the learning, and that it wasn't an entire watershed, but that's not disputed by me, and I think that Nomura expresses things adequately. before I move on to the construction arguments, the only other point I wanted to note before we leave Abbott 2 is very shortly something that my Lord Justice Lewison raised an argument yesterday, which is what was Andrew Baker, Mr. Justice Andrew Baker, saying in paragraph 46, and this was where the Ministry of Defence had argued that although it wasn't saying in 19.1 that the word claim meant cause of action, it meant a claim properly brought pursuant to CPR 7 or CPR Part 8. In paragraph 46, Mr. Justice Andrew Baker said that he didn't agree with that submission, and he said that if there was an irregularity by introducing into a claim form matters that should actually be dealt with in separate proceedings, that could be cured by procedural machinery. So in answer to the question that I understood my Lord Justice Lewison to have yesterday, all that is saying is that a claim form that includes an extraneous claim is not a nullity, but it can be dealt with procedurally. And we say that that is correct. And of course, in Abbott itself, there was a provision for the issue of fresh claim forms with accommodation on the limitation position. Turning then to the construction submissions, as your lordships and your ladyship know, the key points from the divisional court are that the limiting factor on what can go into or who can join in a claim form is provided by Rule 7.3, the convenient disposal test, and claimant is to be read as including the plural. And under CPR 19.1, the word claim means proceedings or action, certainly not a cause of action. Now, the appellant's case is threefold. First, there is a general proposition that in the CPR generally, and in these two rules in particular, claim means demand for or entitlement to a remedy, paragraph 7 of their skeleton, or a claim to relief pursuant to cause of action, paragraph 29 of their skeleton. One could praise that.
So you're going to have to take this a bit more slowly.
Forgive me.
I'm already lost.
Yes.
You are now telling us, are you, what the appellant says
About the
his
meaning
argument.
of the word claim in a general sense.
Right, about the word claim, yes. Okay.
In the CPR generally, and in these two rules in particular.
Yes.
And that submission was persevered in yesterday.
So what submission?
That claim means cause of action, where it is used. That is the general natural meaning of the word in the CPR.
Yeah, okay, good.
Now, we looked at that yesterday.
So you were going to give us three things.
Yes, the third thing is
One, claim means cause of action. What's the second thing?
that in Rule 7.3, claimant means a single claimant. So that's the Interpretation Act point.
Yeah.
And then the third point is 19.1 and the rereading of that rule. To mean
Rereading.
any number of claimants or defendants may join the assertion of a right or rights to relief.
Sorry, it's not very coherent. What are you saying he said, just in a nutshell?
Well,
19.1 means?
that any number of claimants may join a cause of action arising out of a common event or series of linked events. All I'm trying to do is repeat Mr. Stewart's formulation. We say that that's not a correct reading of the rule. He said first of all that 19.1 allows multiple parties to join a cause of action. And the original case was that is the single claimant's cause of action. And your lordship described that as an unbelievably narrow interpretation of the rules.
Yeah.
He then reformulated his understanding of what 19.1 means in the course of submissions to mean causes of action arising out of a common event or series of linked events. So that is the target that I'm now expected to meet, or to aim at. So dealing very quickly with point 1, that claim in the CPR generally means cause of action. That is incorrect. We turned the pages on CPR Part 19 yesterday, and looking at examples, particularly representative actions, which was His Lordship the Master of the Rolls example, and derivative claims, which was one I suggested, it is abundantly clear that as a matter of general meaning, the word claim is not to be equated with cause of action. And one could turn the pages on Part 19 and come up with numerous examples, and indeed in other parts of the rules. It's not my job to establish a single meaning, but the meaning advocated by the appellant is incorrect. So that's it on point 1. Point 2, Rule 7.3, a single claimant. As His Lordship the Master of the Rolls pointed out, that runs immediately into the Interpretation Act problem. And initially, Mr. Stewart KC conceded that, saying, my construction is too narrow for the purpose put forward. He then withdrew that concession when it became clear that it undermines his case more generally, because it makes it impossible to construe 7.3 as focusing on a single cause of action. If you've got more than one claimant coming into a claim form, you are going to have more than one cause of action in most cases. We say that the Interpretation Act plainly applies, and I want to give your lordships and your ladyship 2 references in support of that proposition. First of all, I don't understand that the Interpretation Act applying to the CPR is in any way disputed. It's just a question of does it apply to this rule. In Abbott 2, paragraph 41, Mr. Justice Andrew Baker construed Rule 7.21, which uses the definite article in the singular, the claimant, to include the plural. And we say that that is consistent with the proper construction of 7.3. So that reference is paragraph 41 of Abbott 2, looking at 7.21. It would be completely irrational for rules in the same part of the rule book dealing with starting proceedings to adopt a different approach. Also, it is worth noting that under the rules of the Supreme Court, or the Victorian predecessors at any rate, the singular included the plural when one was dealing with the word plaintiff. And that is clear from the Court of Appeal's judgment in Hannay and Smurthwaite. The point is found most readily on page 91 of the authorities bundle. Page 91 of the authorities bundle, right at the bottom. This is in the judgment of Lord Justice Kay.
It was overruled.
It was overruled, but not on this point.
No.
His Lordship, Lord Justice Kay, deals with Order 18, Rule 1, which is joint of causes of action. That is the ancestor of Order 15, Rule 5, that we were looking at earlier. And that read, subject to the following rules of this order, the plaintiff may unite in the same action several causes of action. And he set out the rest of the rule. And now on page 92, right at the top, he refers then to Order 71, Rule 2. In these rules, unless repugnant to the context, the singular number shall include the plural, and the plural number shall include the singular. And his Lordship continued, therefore, the plaintiff in Order 18, Rule 1 may be read the plaintiffs unless the context forbids. There is nothing repugnant to this in the context. Indeed, any other construction would involve the absurd consequence that if two or more plaintiffs were suing for one cause of action, they could not join another, although one plaintiff might do so. Order 18, Rule 1 does not say one plaintiff or even a plaintiff, but the plaintiff, which includes the plural, the plaintiffs. The Master of the Rolls, Lord Esher, was to the same effect on page 84 of the bundle. That's page 41 in the printed report. And at the top of page 84, his lordship said, "It is true that these rules speak of the plaintiff in the singular, but in my opinion, the effect of Order 71, Rule 2, is that the plaintiff must be read as meaning plaintiffs for this purpose." So that, as I said earlier, joinder of causes of action was important for the Court of Appeal's decision about whether the multi-plaintiff writ could stand or not. Their reliance on that was disapproved of in the House of Lords, but interpreting the singular to include the plural has a long pedigree in our civil procedure rules. And so that is a further reason why Mr. Stuart Casey's concession was well made, and the court should find that 7.3 refers to a claimant or claimants. May include in their claim form all claims that can be conveniently disposed of in a single set of proceedings. Third point, Rule 19.1. The original position, which is now academic, was that the appellant submitted any number of claimants or defendants may be joined as parties to a cause of action. So that was the cause of action asserted by the single claimant under Rule 7.3. That was misconceived because the premise was wrong. Rule 7.3 doesn't focus on a single claimant for the reasons I've just endeavoured to explain. It's also inapt to describe a person joining a cause of action. You don't join a cause of action, you join proceedings. And in my submission, that's why the appellant's point on this was regarded as unarguable in Abbott 2. Just doesn't work as a matter of ordinary language. And there was also the question of what it is you are joining. The appellant was giving a wrong interpretation to the word claim. The divisional court was right to say it means proceedings, not a cause of action. Now, the new case developed orally is that it refers to joining a cause of action arising out of a common event or series of linked events. And we say that that suffers from the defects of the original submission because cause of action arising out of the common event or series of linked events is plainly not in the wording of the rule, and it's the wrong interpretation of the word claim. And it just doesn't meet the divisional court's interpretation of that word as meaning proceedings. It's also introducing unwarranted complexity into the rules. They have to be decoded. The very opposite of simple rules simply expressed, which is what our system is supposed to achieve. And it's inconsistent with the submission on the restrictive nature of 7.3. Under 19.1, you can have multiple causes of action and multiple claims, but 7.3 is restricted to the claims of a single claimant. Now, it hasn't been explained how the construction of 7.3 and 19.1 would work. Does it require the single claimant to issue their claim form, and then for everybody else who wants to join, to make an application to join? That is artificial and highly undesirable. Could have all sorts of consequences, not least in relation to the new joiners tripping up on limitation or for some other reason. But it seems to me to emasculate the proper operation of the rules. Insofar as we're dealing with a cause of action arising from a common event or series of linked events, it's not clear to us how that's different from Order 15, Rule 4. And we would say it isn't different. But that flexibility is supplied by the convenient disposal test anyway, because that can't be narrower than Order 15, Rule 4. I want to move on to a different point now, which is just a very brief review of some of the examples that the appellant gave of where its construction would work. In the skeleton argument, they submitted that more than one claimant could use a single claim form in circumstances where there was a joint claim or a claim arising from the same transaction. Or a claim arising from a unified set of facts. Now, in our submission, all those situations involve more than one cause of action. So those very examples contradict the interpretation of 7.3. It can't be a single claimant with their cause of action if you can allow joint claimants in. Likewise,
if they're joint claimants, so there would be one cause of action.
Well,
it is vested in two people, two or more people.
There are some joint causes of action that would be whole and indivisible, but there may well be other joint causes of action where people have an entitlement to relief, but it is for precisely the same relief.
Well, is that a joint claim or several claim?
It may well be a several claim, in which case it falls into the same problem of introducing two causes of action.
For two passengers in a car that is smashed up by a defendant have two causes of action.
Yes. Well, I don't know if
and 1,000 victims of a disaster like Mariana have 1,000 causes of action.
Yes, yes. In terms of joint claims, beneficiaries under a trust, perhaps.
Partnership.
Or a partnership.
There's plenty of examples where there are joint claims by
perhaps that
multiple
submission
claimants,
is not my
they're not
strongest
particularly
submission.
relevant to us. Yeah.
But nonetheless, same transaction and unified set of facts fall well outside 7.3 on their interpretation of it. And it's not really clear what unified set of facts means. Grenfell Tower was an example discussed in argument yesterday. All the victims of that appalling tragedy would need to issue their own claims. And in my submission, no rational system of civil litigation requires that. There is a case in the bundle that I would ask your lordships and your ladyship to note, which is the Giambroni decision at tab 13. That is a case, tab 13, page 287 of the authorities bundle.
The point wasn't run there, was it? It was just assumed.
Correct. And it's exactly the same as the instant case. That's the point I want to make about this. It's a solicitor's negligence case brought by 185 people. There were two firms of solicitors representing the claimants. As it happens, Pennington Manches was one of them. And the Pennington's claimants used omnibus claim forms, and nobody quibbled with that at any stage.
But it doesn't really, I mean, we're being asked to decide it.
Yes.
Not just to assume it.
No, indeed. But it is simply an illustration of the fact that the court should be very wary of accepting a construction of the rules that means a well-established practice, evidenced in numerous ways over many decades, is in fact wrong.
All big environmental cases are examples.
Yes, and Gooder Walker as well. So I don't think that I need to show you anything in that case. It's just exactly the same type of case where the point wasn't taken and didn't occur to anybody.
Whether or not it occurred to them, we don't know.
Over the page, the next tab in the authorities bundle is McLean and Thornhill, decision of Mr. Justice Zaccarelli. This is a procedural decision, but it's again an example, page 311 of the authorities bundle. Again, it's an example of an omnibus claim form used where people have separate and distinct causes of action. And there is a very helpful explanation of what the common issues lead cases model of trial seeks to achieve, but there is no objection here to the use of a single claim form in those circumstances. Now, we've set out in our skeleton argument many other examples, and I don't think that your lordships and your ladyship will be advantaged by my going through them all. But, and we've also discussed that the examples of multi-claimant litigation given in Abbott 2, paragraph 37, would all be cases where separate claim forms are required. Mariana being the...
Well, I don't think anybody is really saying that there are not 3 regimes under CPR Part 19, perhaps 4 because there's derivative claims, but 3 regimes, 19.1, 19.8 and 19.21. Those are different things, and we're just working out the scope of 19.1.
Yes. 19.1 has been used in all these cases without cavil by anybody, and that...
I think actually of the examples that Mr. Justice Andrew Baker quoted, at least 3 of them were GLO cases.
Yes, not clear whether they started life as a GLO.
No, it's not, I agree.
And of course, Mr. Justice Andrew Baker decided that it was not necessary for an intending claimant in what might become a GLO claim to issue their own claim form.
Not necessary, but it sometimes happens.
Absolutely. But on the appellant's construction, it would be necessary. Because you would have separate and distinct claims. There would be no GLO in place. They would need to issue their own claim form because they wouldn't be able to join in one another's causes of action. Now, it may be that Mr. Stewart would seek to get over that by saying, well, there's a common event or series of linked events. But that doesn't provide a very clear principle for intending claimants working out what they're supposed to do.
I must say it seems to me that what was actually intended by the GLO regime is perhaps not what has actually been achieved. And I remember back in those days when I think it was intended, and there are some lines in the White Book that give that impression, that it was intended actually to sweep up much more than it has swept up.
Yes.
But really that's no part of this case.
No, indeed not. I do say also that the pre-CPR cases in the bundle are consistent with our submission that multiple claimants in our situation could use a single claim form. So if your lordships and your ladyship read the 15.4 test into the CPR, we satisfy that test. I need to say relatively little about them, but I do just want to flag drink, beer and wood.
I don't think, I mean, just to be clear, I don't think reading this, I don't think that's correct language. I don't think you can read 15.4 into the new CPR. All I think you can do is to say that the word convenient should be taken as a very wide word,
yes,
as including what was there before,
yes,
because anything else would not work for a whole host of reasons.
yes,
Consistent with the word meaning of the word consistent.
yes. I don't object to that, my lord, or doubt it. Drink, beer and wood, tab 8 of the authorities bundle. This is at page 109. The only thing that your lordships and your ladyship need to know about this is that it was after the change in the rules following Hannay and Smurthwaite. So it's page 109.
So when precisely was the rule changed?
1896 is my understanding. It was
1896?
Yes.
How do we know that?
It's described by Lord Justice Scrutton in Payne and British Time Recording Corporation, he goes into the history of what occurred, although he says, in fact, that's tab 9 of the authorities.
Which page?
His judgment is 137, and he describes the history of what had occurred. He talks about the Order 16, as it then was, dealing with joinder of parties, Order 18, dealing with joinder of causes of action, the holding in Smurthwaite and Hannay. Then over the page at 138, he makes the point immediately in consequence of those decisions, an alteration was made in Order 16, Rule 1, which dealt with joinder of plaintiffs, and it was extended. He then makes clear that Rule 4, which dealt with joinder of defendants, was not altered, but it is to be read in the same way as Rule 1.
We don't get a date when this
We don't, no. I will check that. It's either 1895 or 1896, and I have looked at every edition of the annual practice from 1893
You must have enjoyed
onwards.
that, Mr. Johnson.
Yes, it took an awfully long time. But,
I bet they were jolly dusty.
They were, but I will supply you with the correct date, my lord. But in any case, he then talks about the fact that the impact of the alteration of the rule was not appreciated at first. That's 138, the paragraph 2/3 of the way down the page. At first, as was said by the Master of the Rolls, this alteration of the rule was not appreciated.
What does that mean?
That people hadn't realised that you could put more than one plaintiff with a distinct cause of action into a writ. They didn't understand that the rules had in fact substantively changed.
Okay. Yeah.
He then says that certain cases would be decided differently now. And then in page 139, he says, as a general approach to construction, the result of the later decisions is that you must look at the language of the rules and construe them liberally, and that where there are common questions of law or fact involved in different causes of action, you should include all parties in one action, subject to the discretion of the court, if such inclusion is embarrassing, to strike out one or more of the parties. It is impossible to lay down any rule as to how the discretion of the court ought to be exercised. Broadly speaking, where claims by or against different parties involve or may involve a common question of law or fact bearing sufficient importance in proportion to the rest of the action to render it desirable that the whole of the matters should be disposed of at the same time, the court will allow the joinder of plaintiffs or defendants, subject to its discretion as to how the action should be tried. And then...
I mean, those two dicta about construing them liberally and being impossible to lay down any rule as to how the court's discretion should be exercised are timeless.
Indeed. And also not, in fact, inconsistent with Andrew Baker Jay's consideration of the common ground among the claims being of sufficient importance to make it convenient for disposal in a single set of proceedings. He then says that the power of the court to allow the joinder of the present defendants is unquestionable. This was a case where a claimant wanted to sue two defendants in relation to distinct breaches of contract in the same action. Broadly speaking, the claimant undertook to supply printed cards for slot machines in the workplace, where one would put a card in to show that one had arrived on time and so on, that sort of card. The plaintiff had undertaken to supply those to one of the defendants and had contracted with the other defendant for the supply of the cards. The customer rejected the cards that were supplied as not conforming to sample, and so the plaintiff sued that defendant for the price of the goods supplied, and he wanted to sue the second defendant for failing to produce goods in accordance with the sample he had given. And so that was the situation before the court. It was a two-defendant case, and the Court of Appeal said that joining those two defendants in that single writ was permissible, and that Rule 4, which dealt with defendants, was to be construed in the same way as Rule 1, which dealt with plaintiffs. And so the rest of...
This was an extempore judgment in which the other side was not called upon. Those were the days.
Yes, quite. 139 is just his decision in the case, and the other judgments are consistent with that reasoning.
Yes, Lord Sterndale says at 134 there's one very important question which is common to both defendants.
Yes.
Mainly whether the cards are up to sample. If that's decided, the rest of the case is, quote, mere fringe.
Exactly. And so that is a decision that would be binding, my lord, on both those defendants, or it would determine the outcome of the litigation. Indeed.
It's marvellous, this case. Mere fringe, I think we'll have to use that in our judgments.
It's only 103 years old.
The only point I wanted to make, the only other point I wanted to make about the authorities is just the drink, beer and wood case, page 109. This postdates the change in the rules. It's 4 people who had taken debentures on the faith of statements in a prospectus and covering letter issued by the directors of the company. They were all suing on one writ. And Mr. Justice Byrne held that they were entitled to do that, despite the fact that they had separate causes of action. His judgment on that question is very short. The rest of the report is actually about the outcome of the litigation. And 112 is where he starts to address this question. He explains the different situation that obtained under Smethwaite and Hannay. He talks about the new order that has come into operation. And then he says on page 113, picking it up about an inch from the top, I have therefore to consider whether the plaintiffs in the present case allege causes of action arising out of the same transaction. If in the present case separate actions had been brought, there would be common questions of law or fact. Perfectly true that if these plaintiffs had not entered into contracts, they could not have a title to relief. The entering into the contract was a separate transaction. All the plaintiffs alleged the right to relief to rise out of the issue of the prospectus containing false statements and therefore out of the same transaction. Then he says, and this is the important part, I do not consider that the word transaction in the rule necessarily implies something taking place between two parties. It is perfectly true that to establish their respective rights to relief, the plaintiffs must prove their title on distinct evidence, but when the plaintiff has proved his title, there is a common ground of action, namely the loss to the plaintiffs caused by the defendants issuing the prospectus. I think, therefore, that the present case does come within the meaning of the rule, and that the defendants are not entitled to say that the plaintiffs must proceed in separate actions. So that's explaining what same transaction under the old rules meant. It's not a bilateral dealing, as I submitted yesterday. It's the common ground of the action. And
houses shaken down by a
Yes,
traction engine passing
that.
along
He must
the
be thinking
highway.
of a very large traction engine or a very rickety house or both.
But
Yes.
either way, the image is just wonderful.
and it conveys in simple terms what was permissible.
Yeah.
And so we would say, looking at drink beer, looking at pain, they'd all have to issue separate writs if the appellant's construction is correct. And the same is true of Hannay and Smethwaite, with which I appreciate your lordships and your ladyship are familiar. And that was, of course, the prompt for the change to these rules. That's all I wanted to say about the
Yeah, I've got another
cases. There are a number of points made in paragraph 30 of the appellant's skeleton argument. I can run through these very briefly. You will, paragraph 30 of the skeleton argument. Page 14 of the core bundle. Under paragraph 30A, it is said that CPR 19.1 would have said, if its effect was that any number of claimants or defendants could be joined. But that is, in my submission, precisely what it does say, and that is the construction your lordships and your ladyship should adopt. 30B is a point about where the word claim is used. That word cannot mean claim form. And this is something that was developed orally yesterday. Mr. Stewart, KC, criticised the Divisional Court for saying that in 19.1 the word claim means claim form. And he took the court to various examples where the two terms are used differently. The simple answer to that is the Divisional Court decided that claim in 19.1 means proceedings. It said it would have been better if it had read claim form, but the actual meaning it attributed to the word is proceedings. And so that's enough for us. 30C is in support of the submission that the word claim means cause of action, which I've already addressed. 30D is a point about the interpretation of the appellant being consistent with the singular use of claimant in Rule 7 and the requirements as to what a claim form must contain. You've already heard me about the impact of the Interpretation Act, which deals with that point. It's not clear what requirements of the claim form the appellant has in mind. And so far as the claim form is concerned, I've already referred you to paragraph 41 of Abbott 2, which deals with the relevant rule, Rule 7.21. In paragraph 30E, the appellant submits that the Divisional Court's construction and its results are illogical and incompatible. And this is not looking at it in policy terms or general consequences, but in terms of how the rules interplay. And it is submitted that 19.1 is the dominant provision which should be found in Part 7. We say that's not right. The dominant provision is Rule 7.3 because that provides the criterion by which claims can be included in the same claim form. In paragraph 30E, little Roman 2, it is stated that there's no restriction of any kind in Rule 19.1. The restriction, as we've said, is found in 7.3. 19.1 doesn't need to have any further restrictions. And paragraph 30E, little Roman 3, Rule 7.3 allows the claimant to use a single claim form to start all claims which can be conveniently disposed of in the same proceedings, but does not say claimants plural may only sue together regarding claims which can be conveniently disposed of. Again, that's dealt with by the Interpretation Act point. If claimant means or can mean more than one claimant, at that point falls away. Your Lordships and your Ladyship heard me say yesterday that the practical consequences of what the appellant urges upon you are highly undesirable. The issue of numerous claim forms in many cases, not just this one, at vast expense to the litigants for no real practical benefit. But I do say it's important to bear in mind the overriding objective and also the purpose for which the power to make the CPR is to be exercised, which is to achieve accessibility, fairness and efficiency, and with the expanded remit, to ensure that the rules are both simple and simply expressed. And we say that the appellant's construction does not achieve that, whereas the Divisional Court's construction does. As would paying appropriate regard to practice under Order 15 Rule 4. It's also unclear on the appellant's construction what role convenient disposal really has. If you're looking at the claims of a single claimant, and you assume that that single claimant is a rational litigant, not trying to bring in wholly, wildly disparate claims into a single set of proceedings, when would it ever arise in practice that one would need to consider convenient disposal? An example given in Hannay and Smurthwaite is of a plaintiff who wants to sue under a bill of exchange and a promise of marriage in the same writ. That would plainly be inconvenient, we can all agree that. But I think that the court should presume that litigants are rational and won't seek to draw in wholly extraneous courses of action. And in those circumstances, if you just focus on one claimant being able to pursue their courses of action, when would anybody ever need to ask would it be convenient to dispose of them in a single set of proceedings? Almost certainly would be, and the rule then becomes redundant. Whereas under the divisional court's construction, it does in fact have a role to play in multi-claimant litigation. Would you forgive me while I turn my back on the court for a moment? Unless I can assist your lordships and your ladyship further, those are my submissions.
No, we're going to hear from Ms. Meach, but I think we're going to adjourn now,
Yes.
and we will resume at midday.